Oh, yes. I put some documents on my 226 drive. Yes, Rule 60B, however, has long been available to provide relief from judgment to losing litigants where justice so demands. The rule states that a court may relieve a party from final judgment on motion and just terms under 5 enumerated grounds, including mistake, newly discovered evidence, fraud, voidness, and judgment satisfaction, and one catch-all provision. The catch-all, Rule 60b-6, provides that a court can relieve a party from judgment for any other reason that justifies relief. Because a judgment constitutes a final decision, Rule 60 creates some tension between justice and finality. To address this tension, the Supreme Court has imposed the non-textual requirement that a movant present extraordinary circumstances justifying relief. Further, in Ackerman versus the United States, the court held movant was not entitled to relief if his own litigation choices caused his predicament. Ackerman. Now, the court reasoned that Ackerman's own deliberate choice to end his litigation prevented him from revoking Rule 60b-6 to reopen his case after learning the favorable result of his co-plaintiff's appeal. Now there's Atkins versus Ingram. Now looks like this fraud is just reason to remove the judgment. Now it could be that the court needs to have a reason to remove that. And I'm just sitting here asking myself why I'm having such a difficult time today. It seems that nobody wants to acknowledge the fraud of using forgeries. The illegal use of the state court seal. Not giving me any due process before issuing permanent support orders. Now maybe you'd like to think about Rule 60B. Now I can prove the fraud. I can prove the fraud in Spokane. I can prove the fraud in Clallam County. In fact, you know what? Jefferson County, I can prove some fucking fraud. Now, why don't you remove me from the docket in Jefferson County, okay? Now, it's an extraordinary relief, but when you use forgeries, when you don't have the petitioner's signature, when there's no actual notice or opportunity to the respondent, and then you serve somebody other than the respondent, I would think any and all of those conditions is a just reason to remove every fucking judgment today. Now, this fraud on the court involves every employee of the court. It involves crisis responders that were shared that I was in Brennan, Washington when I wasn't. It involves mental health evaluators because they are employees of the court when they're paid for a mental health evaluation. It involves every attorney, every judge, and right now. You're going to remove those fucking court orders. Do you understand? And then I'm going to sue for fraud on the court every individual that has sworn that they would not pervert justice.